Thank you for visiting the Miltenberger Law Offices YouTube channel and our website. We are a proven criminal defense law firm in Nebraska, with over 1,000 cases handled and over 12 years of combined legal experience. Our firm has created these audio articles to help educate you on your rights, protect your freedom, and help you achieve the best solution for the charges you are facing. If we are hired for your case, we will never back down, no matter the odds. Orders of Protection, Lawyer, Omaha, Nebraska. You may first learn about a protection order in Omaha, Nebraska, when a sheriff hands you a stack of papers that tells you where you can no longer go or whom you cannot contact. The judge may not have heard your side yet, but the restrictions take effect immediately once you are served. A protection order can remove you from your home, prohibit communication with the petitioner, restrict access to certain locations, affect contact with your children, and prevent you from possessing firearms. Violating the order can also lead to a separate criminal charge, even when the petitioner contacts you first. Being named as the respondent does not mean the allegations have been proven. You may request a hearing, present evidence, and explain what actually happened. However, the deadline to respond moves quickly. Miltenberger Law Offices represents respondents defending against domestic abuse, harassment, and sexual assault protection orders in Omaha and throughout the surrounding area. What to do after you are served with a protection order? Even if the petition contains false or exaggerated allegations, do not contact the petitioner to argue about it. You will have your date in court to tell your side of the story. If you receive an ex parte order of protection in Omaha, read the complete order, review every restriction, protected person, named location, and deadline. Follow it immediately. The order remains binding once a sheriff or deputy serves you with it. Do not contact the petitioner. Do not respond to calls, messages, social media contact, or invitations to meet. Do not communicate indirectly. Asking a friend, relative, co-worker, or child to deliver a message may still violate the order. Record the date of service. The hearing deadline runs from the day you were served. Preserve evidence. Save complete conversations. Call logs, photos, videos, location records, receipts, and witness information. Do not delete or alter anything. A message that appears damaging by itself may make sense when the full exchange is reviewed. Speak with an Omaha, Nebraska Protective Order defense lawyer. An attorney can review the allegations and represent you at the hearing. What is an ex parte protection order in Nebraska? An ex parte protection order is a temporary order issued before the respondent receives notice or appears in court. At this stage, the judge generally reviews only the petition and affidavit submitted by the person requesting protection, known as the petitioner. Under Nebraska Revised Statute Section 26-109, a judge may issue a domestic abuse protection order before a hearing if the petition claims the person is in immediate danger. A harassment or sexual assault protection order may be issued when the judge believes waiting for a hearing could lead to serious harm or loss. The order is enforceable immediately, but its issuance does not mean the allegations have been proven after testimony, cross-examination, and a complete review of the evidence. It means the court found enough in the written petition to impose temporary restrictions before hearing from you. Once served, you generally have 10 business days to request a show cause hearing. If you do not request one in time, the temporary order may become final, typically for a year, without the judge hearing your evidence. Types of protection order in Nebraska. Generally speaking, a protection order is a civil court order restricting certain conduct between the people named in the case. The person requesting it is the petitioner. The person subject to it is the respondent. Although the proceeding is civil, violating the order may result in arrest and criminal charges. Nebraska recognizes 3 types of protection orders: domestic abuse protection orders, harassment protection orders, sexual assault protection orders. Each type has different legal requirements and potential restrictions. Domestic abuse protection orders in Omaha, Nebraska. A domestic abuse protection order applies only when the parties have a qualifying family or household relationship. Under Nebraska Revised Statute Section 42-903, this may include current or former spouses, people who currently live together or lived together in the past, people who share a child, relatives by blood or marriage, current or former dating partners. A casual acquaintance or ordinary business or social relationship does not automatically qualify as a dating relationship. Domestic abuse may include attempting to cause bodily injury, intentionally or knowingly causing injury, making a credible threat that creates reasonable fear of bodily injury, or engaging in sexual contact or penetration without consent. An argument, breakup, harsh message, or unwanted interaction does not automatically establish domestic abuse. The alleged conduct must fit Nebraska's legal definition, and the required relationship must exist. What can a domestic abuse protection order require? Under Nebraska Revised Statute Section 26-103, a domestic abuse order may prohibit contact, communication, threats, assault, or harassment, remove the respondent from a home regardless of ownership, require the respondent to stay away from named locations, award temporary custody of children for up to 90 days, prohibit firearm possession or purchases, address temporary possession and protection of household pets, impose other restrictions the judge considers necessary. Harassment protection orders in Nebraska. A harassment protection order may involve neighbors, co-workers, former friends, customers, business contacts, or acquaintances. Under Nebraska law, harassment generally means repeatedly contacting, following, watching, or bothering someone in a way that seriously frightens, threatens, or intimidates them and has no legitimate purpose. A course of conduct means a pattern or series of acts showing continuity of purpose. It may involve following, calling, monitoring, restraining, contacting, or repeatedly communicating with someone. One unpleasant encounter doesn't qualify as harassment. The number of contacts, their content, the reason they occurred, and whether communication was mutual may all matter. Under Nebraska Revised Statute Section 26-104, the court may prohibit restraint, harassment, threats, assault, disturbing the petitioner's peace, or direct and indirect communication. Sexual assault protection orders in Nebraska. A sexual assault protection order may be requested based on allegations of sexual contact or penetration without consent, an attempt to commit sexual assault of a child, sexual abuse by a school worker, or certain unlawful recording or sharing of intimate images. The seriousness of the allegation does not eliminate the respondent's right to contest it. The court must still determine whether the evidence supports an order and whether the alleged conduct falls within the statute. Under Nebraska Revised Statute Section 26-105, the order may prohibit contact, communication, restraint, harassment, threats, assault, or other conduct the judge considers necessary. How do you contest a protection order in Nebraska? You contest an ex parte protection order by requesting a show cause hearing. The hearing request form should be included in the papers served on you. The form generally must be returned to the clerk of the district court within 10 business days after service. A timely hearing must usually be scheduled within 30 days after the court receives the request. What happens at the hearing? Both sides may testify under oath. Each side may call witnesses. Messages, photos, videos, call logs, and other records may be presented. The respondent may challenge the petitioner's claims, point out contradictions, and provide missing context. The petition and affidavit are generally admitted into evidence unless the judge excludes them. The judge may dismiss the order, change its terms, or leave it in place. How is an order of protection hearing different from a criminal trial in Omaha? It does not decide criminal guilt. The judge is deciding whether the protection order should remain in place, not whether the respondent committed a crime. There is no criminal sentence. The hearing itself cannot result in jail or a criminal conviction. There is usually no jury or prosecutor. The petitioner and respondent present their evidence to a judge. The burden of proof is lower. The petitioner does not have to prove the allegations beyond a reasonable doubt. The hearing is still serious. Testimony is given under oath. The order may place major restrictions on the respondent, and violating it, or lying during testimony, can lead to separate criminal charges. What if you miss the hearing? If you request a hearing but fail to appear, the temporary order may be affirmed as the final order. Missing court does not cancel the restrictions. Evidence that may help fight a protection order. Evidence your Omaha, Nebraska Order of Protection lawyer may use includes complete text, email, and social media conversations, call logs and voicemail messages, doorbell, security, business, or vehicle video, photos of the scene, property, or injuries, location records, receipts, or work records, witnesses who saw or heard the interaction, police reports or medical records, messages showing communication was mutual, evidence explaining a legitimate reason for contact, statements that conflict with the petition, evidence supporting self-defense, common defenses to a Nebraska protection order. The allegations do not meet the legal standard. Anger, arguments, insults, or unwanted communication do not automatically establish abuse, harassment, or sexual assault. The required relationship does not exist. A domestic abuse order requires a qualifying family, household, or dating relationship. There was no course of harassment. An isolated event may not establish the pattern required for a harassment order. The contact had a legitimate purpose. Communication may have concerned children, property, housing, repayment, employment, or business. The communication was mutual. The petitioner may have initiated, continued, or encouraged the contact. The evidence was taken out of context. Selected screenshots may omit earlier messages or responses from the petitioner. The accusations are false or exaggerated. Witnesses, video, location records, or complete conversations may contradict the petition. The respondent acted in self-defense. An injury does not automatically prove abuse when the respondent was protecting themselves or someone else. The respondent was misidentified. Messages, calls, account activity, or in-person conduct may have involved another person. How long does a Nebraska protection order last? Under Nebraska Revised Statute, Section 26-110, an initial protection order may remain in effect for at least 1 year and no more than 2 years. A petitioner may request renewal during the 45 days before the order expires. A renewed order generally remains effective for another year. What happens if you violate a protection order? Under Nebraska Revised Statute, Section 26-118, Order Type: Domestic abuse or sexual assault order. Violation: First violation. Classification: Class 1 misdemeanor. Order type: Domestic abuse or sexual assault order. Violation: Second violation. Classification: Class 4 felony. Order type: Domestic abuse or sexual assault order. Violation: Third violation. Classification: Class 3A felony. Order type: Domestic abuse or sexual assault order. Violation: Fourth or later violation. Classification: Class 2, a felony. Order type: Harassment order. Violation: First violation. Classification: Class 2 misdemeanor. Order type: Harassment order. Violation: Second or later violation. Classification: Class 1 misdemeanor. A violation may involve direct contact, indirect messages, entering a prohibited location, or possessing a firearm when the order forbids it. The petitioner's cooperation or invitation does not override the court order. How Miltenberger Law Offices can defend your Omaha, Nebraska Order of Protection case. Protection order hearings require more than simply telling the judge you disagree. Evidence must be collected, organized, and tied to the requirements for the particular order. Miltenberger Law Offices can review the petition, affidavit, and temporary order. Explain the restrictions and hearing deadline. Help prepare the request for a hearing. Identify allegations that do not meet Nebraska law. Organize messages, photos, records, and video. Prepare witnesses. Question vague, inconsistent, or unsupported claims. Present evidence of mutual contact or legitimate purpose. Raise self-defense when supported by the facts. Seek dismissal or narrower restrictions. Omaha, Nebraska Protection Order Defense Attorney Cody Miltenberger began his legal career with the Douglas County Attorney's Office in 2010 and has more than a decade of trial experience. He understands that the account written in the petition may not be the whole story. Speak with an Omaha Protection Order defense lawyer. A protection order may have been entered before the judge heard from you, but you do not have unlimited time to respond. Miltenberger Law Offices can review the allegations, prepare your evidence, and present the part of the story the court has not yet heard. Call 402-2172-267 or contact Miltenberger Law Offices online to speak with an Omaha Protection Order defense lawyer. Miltenberger Law Offices is a leading criminal defense law firm serving the entire state of Nebraska. We are headquartered in Omaha and serve Douglas County, Lancaster County, Lincoln, Sarpy County, and all of Nebraska. We look forward to helping you with your criminal defense attorney needs.